guidance on the need for political restraint in matters constitutionally committed to other branches, a clear distinction must be drawn when transplanting that decision into the Kenyan constitutional context. The Constitution of Kenya contains an expansive Bill of Rights enforceable under Article 23, broad and explicit judicial review powers under Articles 165 sub-Article 3D, and a constitutional supremacy clause under Article 2 that expressly subjects every excess of power or public power without exception to constitutional scrutiny and accountability. Unlike the United States Constitution, the Constitution of Kenya does not textually commit impeachment proceedings to Parliament in terms of judicial oversight. The place of the political question doctrine within Kenya's constitutional order has been authoritatively addressed by the domestic courts at the highest levels. The Supreme Court elaborated upon this position with specific reference to impeachment proceedings in Mike Mbuvi Sonko versus County Assembly of Nairobi 2022. The court held that courts are permitted to intervene where matters of constitutional violations arise in impeachment processes, reasoning that although impeachment is a political process sanctioned by the Constitution, neither the County Assembly nor the Senate can act outside the confines of the Constitution and the law, for to do so would invariably invite the court's intervention. The Supreme Court clarified that the mandate of the courts was to determine whether the individual's rights, dignity, and fundamental freedoms had been preserved and protected in the process without usurping the powers and functions of the legislative branch of government. Those principles were further articulated in a 5-judge bench decision of this court in Ramogi and 3 others versus Attorney General 2020, where the court held that the critical constitutional inquiry is not whether a dispute is political in character, but whether it raises constitutional or legal questions capable of judicial determination. Where constitutional standards exist against which the impugned conduct may be measured, a court is not at liberty to decline jurisdiction on grounds Tava, which I have mentioned above, the Court of Appeal observed that Article 47 transformed the common law principles of natural justice into constitutional imperatives, such that whenever public power is exercised in a manner affecting legal rights, status, or legitimate expectations, constitutional standards of fairness become directly applicable. In Sholei case, the Court of Appeal reaffirmed that public bodies exercising disciplinary or quasi-judicial authority must act fairly and impartially, and that public confidence in constitutional institutions depends not only on actual fairness, but equally upon its appearance. The rule against bias is one of the oldest and most fundamental principles of natural justice, embodied in the maxim Nemo Judex in causa sua, that no person shall be a judge in their own case. Historically directed at preventing decision makers from participating in matters in which they held a personal, financial, or proprietary interest, the doctrine has over time expanded to encompass circumstances giving rise to a reasonable apprehension that a decision maker may not approach a matter with the requisite impartiality, even in the absence of any direct personal interest. The modern test for apparent bias was authoritatively stated by the Supreme Court in Rai and 3 others versus Rai and 4 others, 2013, KLR, where the court adopted the objective test and held that the inquiry must be conducted from the perspective of a fair-minded and informed observer. The court emphasized that allegations of bias cannot be founded upon speculation, conjecture, suspicion, or dissatisfaction with the outcome of proceedings. There must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker may not bring an impartial mind to bear on the subject. The Supreme Court reaffirmed and elaborated upon these principles in Kaplana, Rawal, and 2 others versus Judicial Service Commission in 2016. Observing that the question is not whether a party genuinely believes that a tribunal is biased, but whether a reasonable and informed observer, having considered all relevant facts, would conclude that there exists a real possibility of bias. The court further recognized that constitutional institutions must be protected from unsubstantiated allegations capable of paralyzing their functioning, and accordingly insisted upon an objective evidentiary foundation before a finding of bias can be made. Similarly, in Tunoi and another versus Judicial Service Commission and another Civil Appeal number 6 of 2016, the Court of Appeal reaffirmed the enduring principle first established in R versus Sussex Justices ex parte McCarthy 1924, 1 KB 256, that justice must not only be done, but must manifestly and undoubtedly be seen to be done, and underscored that public confidence in constitutional institutions depends significantly upon the appearance of impartiality and not merely its substance. From these authorities, several important principles emerge. First, the test for apparent bias is objective, not subjective. Second, the inquiry must be conducted from the standpoint of a fair-minded and informed observer. Third, mere suspicion, political disagreement, dissatisfaction with a decision or an adverse outcome does not, without more, establish bias. Fourth, and critically, there must exist objective circumstances capable of giving rise to a reasonable apprehension that the decision maker did not or could not approach the matter impartially. Jurisprudence further establishes that bias and predetermination, though related in concept, are legally distinct. Bias concerns the existence of actual or apparent partiality or on the part of the decision maker. Predetermination concerns a state of mind in which the decision maker has effectively closed their mind to the evidence and argument and reached a final conclusion before the process has run its course. The distinction was illuminated by the English Court of Appeal in Lewis versus Redder and Cleveland Borough Council in 2008, where the court drew a clear line between predisposition and predetermination. Decision makers may legitimately hold predispositions, inclinations, or preliminary views on matters before them. That is the inevitable consequence of experience and engagement in public affairs. What the law prohibits is predetermination, which is a state of mind so close to persuasion that no amount of evidence or argument is capable of altering the ultimate outcome. In light of the authorities that we have cited, we hold the view that the mere fact that members of parliament or senators public impeachment of His Excellency Gachagua cannot, standing alone, establish constitutional bias. To hold otherwise would render impeachment proceedings practically unworkable and would be inconsistent with inherently political character that the Constitution itself recognizes in such proceedings. Legislators are not expected to approach impeachment as blank slates, devoid of political opinion or prior knowledge. What the Constitution requires is that they remain genuinely open to considering the evidence, listening to argument, and discharging their constitutional responsibilities in good faith and within constitutional limits. We are accordingly not persuaded by the proposition that bias may automatically be inferred from the fact that legislators belong to particular political parties, support particular political positions, or publicly express their views on political matters that may not necessarily be the views of the accuser. Such circumstances may demonstrate predisposition, but predisposition, as the authorities make clear, is not synonymous with predetermination. It is predetermination and not mere predisposition that constitutes a constitutional infirmity. The position of the speakers stand on an altogether different footing. The speakers do not determine the merits of impeachment charges. Under Article 145 and Article 150 of the Constitution, the power to impeach a deputy president is vested in the National Assembly and the state and the Senate, acting through constitutionally prescribed voting thresholds. The speakers neither debate nor vote on impeachment charges. Their function is essentially procedural and facilitative. They preside over proceedings, regulate debate, determine procedural applications, interpret standing orders, and maintain order within their respective houses. They are not, and were never intended to be, the substantive constitutional decision makers on the question of whether an impeachment should succeed or fail. We are accordingly not satisfied with the broad proposition advanced by some of the petitioners that the Speaker's mere participation in the proceedings or involvement in political agreements is sufficient to establish constitutional bias or conflict of interest. The constitutional decision makers under Article 145 and Article 150 are members of Parliament and senators collectively acting through the respective houses of Parliament. We therefore find that the allegations of bias, predetermination, and conflict of interest advanced by the petitioners against the Speaker's members of Parliament and senators are, on the material before this court, no more than bare and unsubstantiated assertions grounded in political inference and suspicion rather than in objective evidence capable of satisfying the test authoritatively prescribed in the Rai, Rawal, and Tunoi decisions.
The other main issue relates to public participation. In dealing with this topic, we address ourselves to three distinct but interrelated questions. First, whether the public participation exercise conducted by the National Assembly met the constitutional threshold required under Articles 10 and 118 of the Constitution. Second, whether the Senate, upon receipt of the impeachment motion, was itself obligated to carry out a public participation exercise before voting on the impeachment. And third, whether the public participation was required at the point of nomination and appointment of His Excellency Kindiki as Deputy President. The petitioners collectively contended that public participation in the impeachment process was constitutionally deficient, inadequate, and in certain stages wholly absent, rendering the entire process null and void. Their challenge was mounted at the three levels, and the petitioner advanced, they attacked the National Assembly's public participation exercise as being deficient, both in substance and procedure. They argued that the public was given less than 48 hours to digest complex charges, that the template used reduced their participation to binary support or not support choice, that His Excellency Gachagwa's own response was withheld, depriving citizens of balanced information, that many venues were inaccessible, changed without notice, or restricted to party members. They also pointed to defiance of conservatory orders requiring constituency-level hearings, the vagueness of the same-day notice of the 5th October 2024, anomalies in the participation report, such as a report support rate exceeding 100%, and tabling of that report moments before the debate. They also concluded that the scale of participation of about 200,000 citizens out of a population of 52 million was negligible and incapable of meeting the constitutional standards. With respect to the Senate, they contended that Senate conducted no public participation at all, no notices were issued, no hearings convened, no submissions received. They emphasized Senate's role was determinative and quasi-judicial, and therefore attracted an independent obligation to facilitate public participation. They argued that this obligation could not be discharged vicariously through the National Assembly, and that by proceeding without its own engagement, the Senate compounded the defects of the Assembly's process and arrogated sovereign power that the Constitution requires to be exercised by the people. Finally, they challenged the approval of H.E. Kindiki as Deputy President and argued that no public participation preceded the vote, yet that approval constitutes what is known as other business under Article 118(1)(b), which requires public involvement. They highlighted the compressed timelines in the Senate impeachment vote on the 17th of October, the nomination of His Excellency Kindiki the same night, and approval by the National Assembly the following morning as evidence that the process was concluded overnight without public input. They distinguished this midterm vacancy scenario from a general election, noting that in elections, the people exercise sovereignty directly through the ballot, whereas in midterm appointments, public participation is the only available mechanism for engaging the people's will, and on that basis prayed for declaration that the nomination, approval, and appointment of His Excellency Kindiki were unconstitutional. The respondents, quite in summary, maintained that the National Assembly's public participation exercise was adequate, it was reasonable, and fully compliant with the constitutional requirements. They argued that notices were disseminated through the Gazette, through newspapers, through Parliament website and social media, and that multiple channels of participation were available. They defended the 2 to 3 day notice period as reasonable, given the strict timelines under Article 145. They further justified the tick box template as a deliberate design to structure responses and prevent manipulation, noting that citizens could still submit their memoranda or oral views. They argued that participation by over 223,000 citizens was characterized as unprecedented civic engagement, and they dismissed the isolated disruptions as immaterial. They argued His Excellency Gachagwa's report with response with the public, since the public's role was to express views, not to adjudicate. On the Senate stage, the respondents, in summary, contended that the public participation was not required as the Senate seats as a quasi-judicial capacity during impeachment and not as a legislature. that Article 118 applied only to legislative business and not impeachment. That impeachment was a single continuous exercise with the public participation required only at the initiation stage. Regarding the nomination and approval of His Excellency Kindiki, they submitted that public participation was not required, that Article 149(1) established a unique self-executing process where the National Assembly voted as an electoral college exercising delegated sovereignty rather than conducting legislative business, that the Constitution's silence on participation in this context was very deliberate, and that elected MPs themselves embody public representation, that the debate was open, televised, and recorded, and they concluded that the nomination, approval, and appointment of His Excellency Kindiki were fully compliant with the Constitution. We have considered the cases advanced by both parties and take the following position on this issue. It is common ground among the parties, and this court affirms that public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Subarticle 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty, though delegated to state organs under Article 1(3), is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizen, but a constitutional right that the state is obligated to facilitate, to protect, and to give full effect to. Under Article 10(2)(a) of the Constitution, public participation is expressly enumerated as one of the national values and principles of governance. Article 10(1) makes clear that the national values and principles of governance bind all persons, state organs, state officers, and public officers whenever they make or implement public policy decisions, apply or interpret the Constitution or any law. The imperative of public participation finds further and specific expression in the context of Parliament in Article 118 of the Constitution, which reads as follows: Parliament shall, A, conduct its business in an open manner, and its sittings and those of its committees shall be open to the public, and B, facilitate public participation and involvement in the legislative and other business of Parliament and its committees. At its core, public participation refers to an active process of interaction and engagement among various stakeholders who have an interest in or are affected by a particular decision or course of action. The word active is of constitutional significance. It signals that the Constitution does not contemplate a passive, cosmetic, or performative exercise in which the exercise is merely notified of a decision, in which the public is merely notified of a decision already made. It demands instead a genuine and substantive process which the people are afforded a real and meaningful opportunity to shape the decisions that affect their lives. In essence, public participation is the mechanism through which the governed speak to those who govern, and through which the exercise of public power is continuously tethered to the will, values, and interests of the sovereign people. The robust jurisprudence on these subjects in Kenya supports this position. The Supreme Court, in the matter of National Land Commission, this is an advisory opinion, application number 2 of 2014, placed the principle of public participation at the very core of the concept of checks and balances in governance, recognizing it as integral to the manner in which various arms of government discharge their constitutional functions. Subsequently, in the British American Tobacco Kenya PLC versus Cabinet Secretary for Ministry of Health, commonly referred to as the BAT case, the Supreme Court delimited the following binding framework for public participation. The principles are that, as a constitutional principle under Article 10(2) of the Constitution, public participation applies to all aspects of governance, that the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation, that the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation, and the onus is on the public entity to give effect to this constitutional principle using reasonable means. That public participation must be real and not illusory. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. That public participation is not an abstract notion, it must be purposeful and meaningful. That public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. That public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. The fact that someone was not heard is not enough to annul the process. That allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the peculiar circumstance of each case, including the mode, the degree, the scope, the extent of public participation is to be determined on a case-to-case basis. Additionally, in Cabinet Secretary for National Treasury and Planning and 4 others versus Okiya Mtata, the Supreme Court held that the constitutional threshold for public participation is one of reasonableness, that the process must afford the public a genuine and meaningful opportunity to be heard, and that Parliament must take reasonable measures to ensure the proposal, views, and suggestions received. The court spoke as follows. In the BAT case, this court established the standard that duty bearers must meet and the threshold courts should use to determine whether duty bearers have fulfilled their obligations with respect to public participation. This threshold is set at a reasonableness standard. In its guiding principles on public participation, this court defined this threshold as follows: that public participation must be accompanied by reasonable notice and reasonable opportunity. Reasonableness will be determined on a case-to-case basis. Close of quote. This and the broader corpus of jurisprudence firmly established that when the Constitution the Constitution demands is not necessarily the most intensive form of participation in every case, but always a form that is meaningful, purposeful, and proportionate to the nature and gravity of the decision being made. This principle finds its clearest expression in the decision of the Constitutional Court of South Africa in Doctors for Life International versus the Speaker of National Assembly and others, where the court held that the degree and nature of participation must be calibrated to the subject matter and the potential impact of the decision on affected persons. The proposition has been consistently adopted by our courts in Mui Coal Basin Local Community and 15 others versus the Permanent Secretary, Ministry of Energy. The Court of Appeal affirmed that decisions of greater consequence demand more robust and substantive engagement, and that public participation ought to be meaningful rather than a tick box exercise. The High Court reinforced this position in Robert Gakuru versus Governor Kiambu County and Institute for Social Accountability versus the National Assembly, where it held that the standard of participation required is directly informed by the gravity and reach of the decision in question. We believe that it is within this rich conceptual context that the courts must approach questions about the adequacy of public participation in any given case, whether arising from the legislative process or from any other exercise of public power in which the Constitution demands the people's involvement. The focus ought to be on whether the participation that occurred was real, substantive, and meaningful. As we now turn to apply these principles to the specific facts of this matter, we do so bearing in mind that the constitutional standard is not one of perfection, but equally it is not one of mere tokenism. The standard is meaningful participation, and that standard must be assessed with rigor, sensitivity to context, and fidelity to the constitutional vision of a government that is truly of, by, and for the people. Certainly, the impeachment of a deputy president is not an ordinary legislative act. It is amongst the most consequential, solemn, and irreversible decisions that any parliament can make. It involves the removal from office of a person who holds the second highest constitutional office in the Republic, and an office to which the holder was elected by the sovereign will of the people through a general election. The gravity of that decision cannot be overstated. It affects not only the individual whose tenure is at stake, but the constitutional architecture of the executive, the stability of government, and the democratic expectations of millions of citizens who cast their vote in the 2022 general election. It is precisely because of this gravity that the public participation required in connection with an impeachment process must be held to a standard that is both qualitatively and quantitatively meaningful. It is equally against this exacting standard that we assess the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua. On the question of notice, the National Assembly adduced evidence that notices of the public participation exercise were published in multiple newspapers of wide national circulation, including the Daily Nation, the Standard, the Star, and Taifa Leo on the 2nd, the 3rd, the 4th, and the 5th of October 2024. We recognize that the publication of the notices in both English and Kiswahili was a deliberate effort to reach citizens across the linguistic divide and to ensure that the exercise was not confined to the English-speaking, urban, and formally educated segment of the population. Notice was additionally published in the Parliament's official website and on social media platform, therefore extending the reach of the process to citizens who access information through digital means. On the question of accessibility and channels of engagement, a public views template was provided in both English and Kiswahili, further reinforcing the inclusive character of the exercise. Constituency offices and county women representative offices, altogether totaling 337 access points spread across every corner of the country, were directed to remain open, including on the 5th of October 2024, to receive public submissions. Citizens were further afforded the option of submitting their views by email, by post, hand delivery, and online submissions could be made through Parliament's website, which further meant that participation was not contingent on physical presence or geographic proximity to a hearing venue. On the question of numbers, the evidence shows that just over 223,000 members of the public participated in the exercise. We are mindful that the significance of a participation number cannot be assessed in a vacuum. It must be considered in the context of the time available, the channels provided, the nature of the decision being made, and the standards previously endorsed by the courts. The Supreme Court in the BAT case affirmed that both quantitative and qualitative components are relevant to such an assessment. Equally, in Robert Gakuru, the Court of Appeal affirmed the principle that the quantitative component of public participation is a relevant but not determinative consideration, and that the adequacy of participation must be assessed in light of all the circumstances. Viewed against these standards, a participation figure of 223 citizens achieved within the constrained timeline represents a considerable level of civic engagement in a single parliamentary process. We say so further considering the relationship between the state's obligation to facilitate public participation and the public's exercise of the right to participate. These are two distinct constitutional responsibilities, and the law does not conflate them. The constitutional obligation that falls upon Parliament and upon all state organs charged with facilitating public participation is an obligation of facilitation, not an obligation of outcome. Parliament is constitutionally required to provide adequate notice, accessible channels, sufficient information, and a genuine opportunity for the public to engage. That obligation, once discharged, exhausts the constitutional duty of the facilitating organ. At least that is our understanding of the Supreme Court's pronouncement in Cabinet Secretary for National Treasury and Planning that, I quote, based on the textual markers herein, Parliament's duty is to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. As is plain from its wording, this provision only imposes a duty to facilitate public participation and involvement in the legislative process, end of quote. We hold the view that what the public chooses to do with the opportunity is a matter of individual and collective civic agency, and that agency belongs to the people and not to Parliament. To hold Parliament responsible for the volume of public participation and to judge the constitutional adequacy of a public participation exercise by the number of citizens who choose to avail themselves of it would be to conflate the duty to provide an opportunity with the duty to compel its uptake. We take the position that a process that was accessible to all but availed by a few is not, by reason of low turnout alone, constitutionally deficient, provided that the low turnout was not the product of inadequate notice, inaccessible venues, suppression of participation, or any other failure on the facilitating organ. This principle finds support in comparative jurisprudence. The Constitutional Court of South Africa in Doctors for Life International case was emphatic that Parliament bears a duty to facilitate public participation and that the standard against which that duty is measured is one of reasonable facilitation. It therefore follows that the adequacy of the exercise ought not to be measured by the number of members of the public who ultimately chose to engage or by whether any particular outcome was achieved. The true measure is whether the state discharged its obligation to create conditions in which meaningful participation was genuinely possible. We are therefore persuaded that the appropriate legal standard against which compliance by the National Assembly must be measured is not one of perfection, but one of reasonable sufficiency in the circumstances. As we have stated, the Constitution does not demand flawless execution of public participation. What it demands is a genuine, accessible, and meaningful opportunity for the public to be heard. Even accepting, as we do, that logistical and operational challenges may have arisen in certain isolated cases, which is not an uncommon occurrence in any large-scale nationally coordinated exercise conducted under time pressure, such localized efficiencies would not invalidate the entire process, as guided by the Supreme Court in the BAT decision. The evidence before this court shows that the door was opened widely, accessibly, and in good faith. Additionally, the fact that His Excellency Gachagwa's response to the charges was not availed to the public during the window does not, without more, render the exercise deficient. The purpose of public participation in the impeachment process is substantively and functionally distinct from the adversarial hearing to which the respondent is entitled. The public was called upon to express its views on whether the allegations assessed on their face were of sufficient gravity to warrant a removal of a constitutional office holder. It was not and was never intended to be a mini trial of the charges. The Constitution vests the final decision-making authority in the National Assembly and the Senate, both of which are representative bodies exercising a delegated mandate from the people. These institutions heard, considered, and weighed both the allegations and His Excellency Gachagwa's full response before proceeding to vote. On the question of compliance with the court orders of 3rd October 2024, which directed the National Assembly to organize public participation at least at constituency level, we find upon careful evaluation of the evidence placed before us that the National Assembly took demonstrable and timely steps to give effect to those directions. A memo from the Clerk of the National Assembly contained at page 996 of the National Assembly's document provided as follows. The title of the memo was Collection of Public Views on the Special Motion for Removal from Office by Impeachment of the Deputy President of the Republic of Kenya. And the Clerk of the National Assembly writes, as you are aware, the National Assembly is currently considering a special motion for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. To facilitate this process, public hearings were scheduled to be held in all 290 constituencies on Friday, October the 4th, 2024, from 8 to 5 p.m. And members of the public were notified to submit their views to the constituency or county. Offices of all members of Parliament of the National Assembly notified to submit their views to the constituency or county offices of all members of Parliament of the National Assembly. By a court order issued on the 3rd of October 2024, the High Court in Kenya sitting at Kerugoya directed that the National Assembly organize similar public hearings closer to the citizens, at least at constituency level, on each constituency in Kenya to enable the constituents of members of Parliament responsible for the impeachment process nationally to engage with and participate on hearings and or any other suitable modes by which citizens at that level can participate and offer their representations. In this regard, you are required to continue facilitating and coordinating the public participation exercise on the special motion within your constituency or county office. Please ensure that you implement the following: availability of forms. Ensure that copies of the public views template are physically available in your offices. In addition to the physical forms availed earlier, additional forms can be downloaded from the Parliament's website. 2. Collection of views. Collate all views, including memoranda, completed public views template, and any other submissions relating to the exercise. Note to transcribe oral submissions into written form using the designated template. 3, submission of collected views. You are required to submit the collated views arranged per constituency to the collection center, which has been set up in Parliament Building, Nairobi, at the entrance of Bunge Tower. Alternatively, you may hand over the forms to the respective officers designated for your counties or constituencies as per the attached list. All submissions must be received by Sunday, the 6th of October, 2024. Please ensure that your respective offices remain open on Saturday, the 5th of October, 2024, as from 8 a.m. to 5 p.m. to facilitate the exercise. Please utilize the operation facilities and resources available in your offices to print or photocopy the forms and to support any other aspects of this exercise. For seamless coordination, we have shared the contacts of parliamentary officers responsible for each county or constituency. I close the quote. The petitioners allege that no actual hearings were held at the constituency level, contending in effect that the exercise was a procedural facade. The allegation was effectively countered by substantial evidence presented by the National Assembly participation on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, the Deputy President of the Republic of Kenya. The report contained a detailed analysis of the aggregated constituency tallies. See table number 4 at page 180 of the report. Supported by photographic documentation of the exercise conducted across multiple constituencies, as well as an official account comprehensively outlining the scope and substance of the proceedings. It is a well-settled evidentiary principle that a bare denial or unsubstantiated allegation cannot displace positive and particularized evidence to the contrary. The petitioners bore the burden of proving on a balance of probabilities that the public participation was an illusory or ineffective exercise. That burden was not discharged. It was also common ground that the public participation was tabled before the National Assembly on the 8th of October 2024. Members of Parliament had the opportunity to consider it before and during the debate. One of the petitioners mounted a specific and pointed challenge to the integrity of the report's data, contending that the figures recorded for Keio South were statistically impossible in that they purportedly reflected a support rate of 162.78%, a figure that, if accurate, would self-evidently exceed the mathematical ceiling of 100% and thus portray either gross error or deliberate manipulation. We have subjected the report to careful scrutiny. Our analysis shows that in Keio South, of the 820 responses recorded, 807 supported the impeachment, 12 opposed it, and 1 selected other. This translates to 98.41% in favor, 1.46% against, and 0.12% categorized as other. These figures, in our view, are mathematically sound and fall within the permissible range of 0 to 100% and disclose no statistical anomaly of the kind alleged. The petitioner's contention, presented as a statement of fact, is therefore not borne out by the document itself. We further find that even if isolated errors were present in data entry, tabulation, or transcription, If those errors were demonstrated to exist within a report of this scale, such minimal errors would not without more vitiate to the entirety the otherwise lawful and substantially compliant public participation exercise. Therefore, having wholly examined the totality of the evidence produced before us, and having applied the constitutional and jurisprudential standards authoritatively laid down on the nature and quality of public participation required, we are satisfied and hereby find that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua as Deputy President met the requisite constitutional threshold in all material respects. With regards to the Senate not conducting its own public participation, the petitioners contended that the Senate acted in violation of Article 118 of the Constitution by failing to conduct its own independent public participation exercise prior to deliberating on the impeachment of His Excellency Gachagua. This argument, while not without surface appeal, cannot be sustained upon a careful and purposeful reading of the constitutional architecture governing impeachment proceedings, and we reject it for the following reasons. The starting point is a principle of constitutional specificity. Where the Constitution makes express and particular provision for a specific process, that specific provision governs, and general provisions must yield to it to the extent of any inconsistency or tension. Article 145 of the Constitution prescribes with particularity the role and function of each House of Parliament in the impeachment process. Under that provision, the Senate's designated function is to hear the charges preferred against the Deputy President, to receive and evaluate evidence in respect of those charges, and to decide on whether the Deputy President should cease to hold office. This is, by its very nature, an adjudicative function, and one that is quasi-judicial in character, akin to the conduct of a tribunal. It is not a legislative or policy-making function. The Senate, at this stage of the process, sits not as a law-making body, but as a constitutional adjudicator, and the procedural obligations that attend to that role are correspondingly different. Article 118, by contrast, imposes obligations on Parliament in the conduct of its legislative and other business. It provides in material part that Parliament shall conduct its business in an open manner, that its sittings and those of its committees shall be open to the public, and that Parliament shall facilitate public participation and involvement in its legislative and other business. The operative phrase is legislative and other business, and the interpretive question is whether Senate's adjudicative role in impeachment proceedings falls within the scope of that phrase. We find that it does not. The phrase other business must, on a proper application of the Eusdom Generis canon of construction, be read as business of a similar nature to legislative business. That is, business involving the formulation, review, or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru, that public participation in impeachment proceedings primarily occurs at the county assembly level rather than at the Senate level, since the county assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for final determination. End of the quote. At the Senate stage, the function being discharged, as we have said, is adjudicative rather than consultative. We find that the constitutional principle underlying that holding is not confined to the impeachment of governors. It is a principle of general application that derives its force from the structural logic of the impeachment framework embedded in the Constitution, and it applies with equal force and validity to the impeachment of the Deputy President under Article 145. A second invocation of the same procedure in respect of the same charges, the same allegations, and the same subject matter at the Senate level serves no additional constitutional purpose. We therefore find that the Senate did not violate Article 10 or 118 by failing to conduct its own independent public participation. Finally, the question of whether public participation was constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President calls for a holistic interpretation of Article 149(1) of the Constitution, read in its proper textual, structural, and purposive context. Article 149(1) provides in express and unambiguous terms that within 14 days after a vacancy in the office of Deputy President, the President shall nominate a person to fill that vacancy, and that the National Assembly shall vote on the nomination within 60 days of receiving it. The correct approach to that interpretive exercise is well settled. The Supreme Court affirmed in the matter of the principle of gender representation in the National Assembly and Senate that constitutional interpretation must be holistic and that no provision of the Constitution may be read in isolation, divorced from the broader architecture of the document of which it forms part. The court elaborated the context of that holistic approach in the matter of Kenya National Commission on Human Rights, holding that holistic interpretation requires contextual analysis, which is reading a constitutional provision alongside and against related provisions so as to arrive at a rational and principled understanding of what the Constitution must be taken to mean, having regard to its history, the issues in dispute, and prevailing circumstances. It is this disciplined, context-sensitive methodology that we apply to the question at hand. A holistic reading of Article 149(1) in its contextual context reveals compellingly that this provision is self-executing. It prescribes a complete and self-contained procedure of nomination by the President within 14 days, followed by a vote by the National Assembly within 60 days. It makes no cross-reference to any other article for supplementary procedure. Critically, it makes no mention of public participation, nor of committee vetting, nor of any other consultative mechanism. The framers of the Constitution were not silent on public participation by inadvertence. When they intended to require it, they said so in express terms. Article 118(1)(b) expressly mandates Parliament to facilitate public participation in its legislative and other business. The deliberate omission of any equivalent requirement from Article 149(1) is itself a constitutional signal that must be given interpretive effect. To read a public participation requirement into Article 149(1), where none appears in the text, would be to engage in precisely the kind of unbridled extrapolation that the Supreme Court cautioned against in Kenya National Commission on Human Rights. The constitutional text of 149(1) is further instructive in its precise choice of language. The provision directs that the National Assembly shall, and in quotes, vote on the nomination. This is a deliberate linguistic choice by the constitutional drafters, and it is not open to a court to substitute its own preferred terminology for that which the Constitution has expressly employed. As the Speaker of the National Assembly correctly ruled, the phrase vote on connotes an electoral determination so that the National Assembly was in constitutional substance electing the Deputy President from among the nominee presented by the President and not approving an executive appointee in the manner of a parliamentary vetting process. That interpretation is faithful to the constitutional text and is consistent with the structural design of that provision. This understanding is further reinforced by Articles 1, 2, and 1, 3 of the Constitution, which vest sovereign power in the people and provide for its delegation to, among other organs, Parliament. When the National Assembly votes on a nominee for Deputy President under Article 149(1), it is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution makes a deliberate structural choice not to provide for a by-election to fill a mid-term vacancy in the office of the Deputy President, electing instead to vest that determination in the National Assembly as the people's primary representative institution. That choice reflects a conscious constitutional calibration of the respective roles of participatory and representative democracy, a calibration that this court is bound to respect. To accept the petitioner's contention that public participation is a constitutional prerequisite for every decision of constitutional importance would be to obliterate the distinction between participatory and representative democracy and to impose an obligation on the National Assembly to conduct public participation before every significant vote, including the election of the Speaker, the Deputy Speaker, and appointment of committee chairs. That is plainly not what the Constitution requires. As this court confirmed in Okoiti and 6 others versus Cabinet Secretary for National Treasury and Planning, where it was held that the representative democracy as a complement to participatory democracy is independently and fully constitutionally recognized. The Supreme Court stated as follows, that Article 1.1 declares that the sovereign power belongs to the people of Kenya, and that power can be exercised only in accordance with the Constitution. Article 1.2 further proclaims that the people may exercise their sovereign power either directly or indirectly through their democratically elected representatives. It is this direct democracy aspect the Constitution provides for citizens to participate in referenda on certain constitutional amendments as outlined in Article 255. Additionally, it promotes a participatory approach to governance with Article 10.2a identifying democracy and participation of the people as national values and principles of governance. This is reinforced by specific constitutional obligations such as the duty imposed on Parliament under Article 118 1B to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1.3 states that sovereign power is delegated to specified organs, state organs, including Parliament and the legislative assemblies of county governments. Moreover, Article 94.1 of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149(1) is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even were one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercised their votes. We are therefore satisfied that this openness and transparency, which is the constitutional core of Article 118(1)A's requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce itself on the National Assembly's Standing Orders number 64(2) and 65, as well as Senate Standing Orders 75, 78, 79, and 80. Beginning with the National Assembly, some of the petitioners assailed the constitutionality of Standing Order number 64(2), contending that the provision imposed an impermissibly truncated 7-day timeline for the disposal of impeachment proceedings. They argued that such compressed timelines undermined meaningful public participation and curtailed the rights to a fair hearing guaranteed under the Constitution. They thus prayed for a declaration that Standing Order 64(2) is unconstitutional, null and void to the extent that it prescribes a timeline that is incompatible with constitutional requirements for public participation, fair hearing, and compliance with court orders, and an order of certiorari to quash Standing Order number 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. The respondents in answer defended the constitutional validity of Standing Orders 64(2) and 5, contending that they are necessary for the expeditious conduct of impeachment proceedings. They pointed to the Constitution itself as a source of the condensed timelines, including Article 145(2)A, which requires the Speaker to notify the Senate within 2 days, Article 145(3), which requires the Senate to convene within 7 days, and Article 145(4), which requires a special committee to report within 10 days, and submitted that it would be illogical to impugn a standing order that prescribes a 7 to 12-day time frame when the Constitution itself operates within a similarly compressed time frame. The respondents further submitted that Article 124(1) expressly empowered each House of Parliament to make standing orders for the orderly conduct of its proceedings, and that Standing Order 64(2) is a legitimate and necessary operationalization of that constitutional framework. They urge the court to exercise restraint in accordance with the separation of powers on the issue. Having carefully considered the rival contentions of all the parties, we now pronounce ourselves as follows. It is trite that standing orders are subordinate legislation deriving their authority not from Parliament itself, but from the Constitution. Article 124(1) of the Constitution expressly empowers each House of Parliament to make standing orders for the orderly conduct of its proceedings, including those of its committees. Article 124(2) further entrenches the role of parliamentary committees within this framework. Being creatures of the Constitution, we agree with the submission that standing orders must at all times conform to the spirit of the Constitution, its values and animating principles. They cannot rise above the instrument that gives them life. Standing Order 64 prescribes a procedure for removal of the Deputy President under Article 145 of the Constitution. Standing Order 65(2) extends this procedure with necessary modifications to the impeachment of a Deputy President under Article 151(b) of the Constitution. Standing Order 64(1) requires that a member seeking to initiate such a motion must submit it in writing to the clerk, clearly stating the grounds of removal supported by at least 1/3 of all members. The motion must particularize the alleged gross violation of the Constitution or other written law, cite the precise provisions alleged to have been violated, and be accompanied by evidence sufficient to substantiate the allegations. The specifically impugned provision, Standing Order 64(2), stipulates that such a motion shall be disposed of by the Speaker within 3 days in accordance with Standing Order 47, and thereafter by the Assembly within 7 days of notice. Should the Assembly fail to act within that period, the motion is deemed withdrawn and may not be revived in the same session save with the leave of the Speaker. The combined effect is that once an impeachment motion is properly filed, it is subject to strict and unforgiving timelines. 3 days for the Speaker's action and 7 days for the Assembly's disposal, failing which the motion lapses in its entirety. It is these rigid timeframes that the petitioners impugned as unconstitutional. Now, the constitutional provisions engaged by the challenge are uncontested. Article 2(4) of the Constitution, which provides in terms that admit of no ambiguity that any law, including subordinate legislation that is inconsistent with the legislation with the Constitution, is void to the extent of the inconsistency, and any act or omission in contravention of the Constitution is invalid. Article 50, which guarantees the right to a fair hearing, and Article 10 and 118, which further enshrine public participation as a constitutional obligation binding on all state organs, including Parliament, in the exercise of their functions. We have examined at length the constitutional requirements and parameters that govern public participation in impeachment proceedings, and we have set out the applicable principles in detail in the preceding sections of this judgment. In determining whether the timelines in the impugned standing orders contravene these constitutional imperatives, it is not lost on us that Parliament is not a resource-constrained institution. It possesses the institutional capacity, the administrative infrastructure, and the constitutional mandate to reach every part of the Republic through its structures at both the county and national levels. If Parliament genuinely considered 7 days to be a sufficient window for public participation, it bore a corresponding constitutional obligation to deploy its resources adequately. to ensure that the process was not merely open in form, but accessible in fact, and that it met the participation threshold authoritatively settled in the BAT decision. A compressed timeline, standing alone, is therefore not necessarily a constitutional infirmity. A compressed timeline, accompanied by an under-resourced and inadequately facilitated process, is an altogether different matter. Still, the question that this court is required to answer is whether 7 days, encompassing the logistical demands of public notification, the organization of participatory forums across a diverse and geographically expansive republic, the receipt and meaningful consideration of public input, and the Assembly's own deliberation on a matter of this constitutional gravity is structurally adequate to meet that threshold. We draw from the Supreme Court of Canada's holding in Hyde Nation versus British Columbia, Minister of Forests, a 2004 decision, that the adequacy of any participatory process must be measured against the gravity, as we have said, of the decision that is being made, and that the more consequential decision, the more robust the participation exercise must correspondently be. At the same time, we are mindful of the importance of according appropriate deference to Parliament in the regulation of its internal proceedings as required under Article 124(1) of the Constitution. In the Supreme Court decision in the Speaker of National Assembly versus the Attorney General, the Supreme Court stated that the court would be averse to questioning parliamentary procedures formulated to regulate internal workings, and the court would not do so as long as the same do not breach the Constitution. Having regard to all the foregoing, we do not consider it warranted to declare Standing Order 64-2 unconstitutional. A declaration of unconstitutionality is a remedy of last resort and a judicial act of the gravest constitutional consequence, not to be visited against upon rather a legislative provision where the provision is capable of a constitutional interpretation or application. We are further guided by the principle of constitutional avoidance that where a provision of subordinate legislation can be read and where it can be applied in conformity with the Constitution, the court ought not to strike it down when a less drastic remedy is available. This principle was affirmed by this court in IEBC versus Minor Kai and 5 others, where it was held that interpretive generosity must extend where reason permits to the provisions whose constitutionality is challenged. We are not persuaded that the mere existence of a 7-day timeline taken in isolation and on its face renders Standing Order 64-2 void. A provision is not unconstitutional simply because it is capable of being applied unconstitutionally. The vice lies not in the number of days prescribed, but in what Parliament does or fails to do within those days. The timeline, considered as an abstract legislative proposition, is therefore not in itself the source of any constitutional infirmity. The infirmity, where it arises, lies in the manner of implementation, and in whatever Parliament operating within that compressed window deploys, whether rather Parliament operating